felony offender. Offense, habitual offender to aggravated rape. Sentencing date, March 13, 1998. Sentenced to 50 years hard labor. Parole date is August 1st, 2021. Good time, not eligible. Full term, March 8th, 2048. Is this information correct, sir?
Yes, ma'am.
Thank you. Ms. Renazzo.
Good morning, Mr. Pierre.
Good morning.
Mr. Pierre, my name's Cheryl Renazzi. Your case has been assigned to me, so I'll start out with the interview process. So is this is your first time before the parole board, is that right?
Yes, ma'am.
You were recently resentenced?
No, ma'am.
No?
No, ma'am.
So when did you learn that you were parole eligible?
When the law became effective August the 1st of this year.
Act 122. Okay, I see.
Yes.
So as I look at your record, I see that you completed all 4 phases of the sex offender treatment program. Is that right?
Yes, ma'am.
You have your conduct record has improved. You have a total of 63 write-ups. And you've been in, how long you been in jail? About 23 years?
Right. I believe like 4 months from 25 now.
Oh, 25 years. Okay. So in that time, you've received 63 write-ups, the last of which was in 2019. One of the things that when I looked at your record that was a little concerning to me is I look at your criminal history, and you were on supervision at the time this attempted aggravated rape occurred. But when a prior conviction, even though it was an unauthorized entry, the record indicates there was a rape also in that case. So that concerns me. Tell me what you learned, the most important takeaway you learned through your participation and completion of the sex offender program.
Ma'am, I've learned the importance of having self-control, ma'am, and just understanding victims' rights and respecting the rights of others, accountability, not pointing the finger of blaming, and just respecting the lives and the decency of other people. And respecting their dignity and just accepting accountability.
Okay. Are you on a light duty crew right now?
Well, I'm scheduled as light duty indoors. I do just various functions. I help out in the clean up, various things because of I have one eye and I have a limited bending and limited stooping due to that because I tore my meniscus in my knee. But I can work but right now I'm just like light duty indoors.
So what should you be granted favorably today? Tell us what your plan would be. Where would you live? How would you live? How would you support yourself?
I've submitted an interstate compact to Jacksonville, Florida, to stay to live with my sister because I believe, and my family, my son and my sister also believe that Jacksonville, Florida would offer me more, would be more beneficial to me. It would be a better place for me to start my life over after all these years, and it would have more to offer without a lot of the crime and stuff that's going on in New Orleans right now.
You would live with your sister?
Yes, ma'am, Valerie Washington.
She's here today, so we'll hear from her shortly.
Yeah, she's
How,
accepted.
how about what would you do to pay your way, support yourself?
She has a business, a flea market that sells T-shirts, all kind of whatnots, glitter, whatnots, Avon, and
So you'd
she,
work for her.
yeah, I would work for her.
You work for her business.
Her
Okay.
business.
Cool.
And she really needs somebody to help her right now because I talked to her recently. She said a lot of people that she's hiring, they're being dishonest and stealing, you know. So it would be a perfect for me to come into and, you know, try to make the business, you know, prosper and grow. And at the same time, it would help me grow and prosper.
All right. I don't have any other questions. I've reviewed your record very carefully. I'll ask Warden Day for his comments.
Yes, you know, reviewing his record and speaking with him, Ms. Renatza, he has greatly improved his disciplinary record. I think 2019 was his last write-up. He does help out on the dormitory here. You know, he has taken the classes. So since I've been here, he's been a pretty solid offender. So
Good to hear. Thank you so much. That's all I have, Mr. Wise.
Thank you very much. I see today Mr. Brian Wilson, Dr. Brian Wilson here to speak for his son. You could go ahead.
Hi, good morning, everyone, and thank you for this opportunity to speak on behalf of my father, Derrick Pierre. I am speaking in support because his family, we really miss him, and my father has carried me through numerous aspects of my career journey, even developing as a man. His ability to transcend where he is, to impact me, to still have a positive impact. And I stand as a testament to his positive influence in my life. But what's most important here is that I believe he has the same impact to do that for others. And so his release will bring an awakening to allow him to really help others. I'm 35 years old, so I'm not a child anymore, but I think his background could really be a strong force to liberate people, to help them understand that they can come back to society and make an honest contribution. And I'm looking forward to his contribution. He's an excellent communicator. He's an excellent writer. I know we talked a little bit about what he's going to do when he comes out, but he also has worked as a legal aid. He is astute in the law and the legislation of the state of Louisiana. And I think he can be of real help once he comes back on the other side. And so I'm here just supporting him, and I look forward to giving him a big hug when he comes home.
Okay, thank you. Very well said, Mr. Wilson. At this time, it's Valerie Washington. Unmute your mic.
Hello, hi, I'm sorry. I'm Valerie Washington. I'm Derrick Pierre's sister. I currently live in Jacksonville, Florida, and I told him that he can come here. I have a 5-bedroom, 3-bathroom home, so there's more than enough facilities to accommodate him. As he stated, I have a business that I need help with. I think the move, I think if he comes here, I think it would be more beneficial to him as far as just having a clean slate to start with. We do miss him. You know, my mother and father have both transitioned while he was incarcerated. So it's me, he, my sister and I, we're of course, and his children. But I think it would be more beneficial for him to, you know, once he's he's released. I believe he's, you know, speaking with him. He's paid his debt. He's understanding. He understands, you know, what exactly, you know, is expected of him, what he needs to do, and just like I said, speaking with him, I think he has his head on straight. And I just think it would be beneficial for him to be, to just be released and back into society. Thank you.
Okay. Thank you, ma'am. At this time, anything you'd like to say to the board before we vote, sir?
I just want to thank y'all for this opportunity, and I also want to express that I don't take my charge lightly, and it's not a day that goes by that I feel remorse for my actions. I own it, I accept it, and I just want to make amends for it, and possibly, like my sister just said, go out back into society and maybe start some type of programs and just, start showing, the impact that crime brings to victims, and just promote more victim awareness. Because a couple of classes that I was fortunate enough to take here, they had victims come here and talk to us and was asking us, why they should be remorseful, and guys, was steady coming at them with angles, well, what about this? What about that? And they were just telling us, they was countering with how the harm that was done to them. And I think a lot of people need to, if that was more advocated more, I think it would kind of like possibly stop, crime, because people, they don't really look at the harm that's done when crime is committed. And I would want to lay up here and go advocate that and push forward on that. And once again, I just thank y'all for this opportunity.
Thank you, sir. At this time, Ms. Renaissance will be voting. Unmute your mic, Ms. Renaissance.
Sorry, thank you. Mr. Pierre, you mentioned, and I think that your family has agreed the best plan is in Jacksonville. Have you submitted an interstate compact yet?
Yes, ma'am.
You have?
Yes,
Have
ma'am.
you heard back?
No, I was informed that the application would not be submitted until a favorable decision is rendered today.
Right. And Dr. Wilson, where is your residence?
I reside in New Orleans.
You're in Louisiana? Okay.
Mhm.
That my concern is, I do believe, I agree with, my vote's going to be to grant you parole. I want to get that out of the way. I think you've done well. You score low on the static 99, which is a risk tool for sex offenders. On our Tiger risk assessment, you also score low. You do have some law enforcement opposition, but you've been in jail a long time. And I like what I heard you say today. I would like to see you go to Jacksonville. But I know that's going to take a while. That process of approving that's going to take a while. I don't know if it's a possibility, if you could be released sooner than before the approval, that you might could stay with Dr. Wilson until such time as that agreement is approved. If my colleagues don't object, I would vote for that. I do want you to go to the special condition is that you go to the Jacksonville plan. And then I won't add it as a special condition, and I'm just one vote. You got to get all three. But I do encourage you to, once you get to Jacksonville, if that's where you land, that you do community service work, advocating for victim awareness. I think that's, you're very articulate. You speak well, and I think you can make an impact. Good luck to you, sir.
Thank you, ma'am.
Mr. Roche.
Thank you, Mr. Wise. Mr. Pierre, good morning.
Good morning.
Mr. Pierre, I look at your case in a different perspective. The victim of this offense, of this egregious crime, was contacted, and she is still emotionally, mentally, and physically affected to the point where she refused to talk to the parole officer who was trying to get a comment in your case. She said, please don't bother me. I don't want to bring this up again. please do not contact me, which tells me that she's still affected by the crime that you perpetrated on her. And I look at it from the victim's point of view. Law enforcement made a comment that usually says opposed, not opposed, but law enforcement comment saying that you had not even served half of your sentence, which is true. Because of law enforcement, because of victim opposition, because of your write-ups in 2019, you had been incarcerated for almost 22 years and you were still getting write-ups. And you've taken all 4 phases of your sex offender treatment, but you've taken little programming besides your sex offender treatment. You still backlog for many, many programs. I'd like to see you get more programs, Thinking for a Change, anger management, victim awareness, substance abuse. We have not taken any of those programs. For all those varied reasons, I'm going to deny your request this morning.
You know, as we were talking a little bit, did you complete all 4 phases of your sex offender programs?
Yes, sir. And I've also completed the counseling part where I went back and I was a counselor.
Okay, all right. Yeah, I was looking on there where it says counsel, but anyway, today I'm going to I vote to grant the same condition Ms. Renata said. You've been down a long time, but I would grant to an approval of a residence plan with either Mr. Wilson only or out-of-state plans with your sister only. Okay?
Okay, thank you, sir.
At this time, I think the vote, it was a 2-1 vote here today. You've been denied today on this case. Thank you.
You know, what's interesting is that his son and also his daughter, but I think primarily his son, almost swayed me to want to root for him. And I think he even swayed Jim Wise. Jim Wise, I gave the first comment that I can recall to really anyone. He said, what did he say? He said, well, he like acknowledged a supporter and said, well said. And you know, you're thinking, well, he served 25 years as for attempted aggravated. And then you're reminded by the beginning where Mr. Renata said that this was his second time that he was caught forcing himself on a woman. And when you take deals of attempted aggravated and like Mr. Renata said, the unauthorized dwelling, and they drop it down, that's because those are things that the DA does to make you take plea deals. And if you recall, Mr. Renata also said, oh, did you get a new trial? And the answer is no. So then how come he can have parole if he had a 50-year sentence? And that's because of, again, Act 122. Act 122 was passed was legislated by the Parole Project because it made it so that all these people would get opportunity for parole, and then Parole Project can take them and make a lot of money. It's just really diverting funds from one place to another. And anyways, it was passed, and it allows anyone who has served more than 20 years, who is also above the age of 40, to now become eligible for parole, almost regardless of how horrific their crime was. Almost, not. it's not, it doesn't fall under, I don't think you can take actually, I don't know where they draw the line anymore. I'm quite confused. But I should double check that. But anyways, it is true what he said about him understanding the law from the records that Richard found. He had this was kind of interesting, where so before Act 122, he was trying to find ways to shorten his sentence. I mean, imagine sitting on a 50-year sentence without the opportunity for parole. You're going to try to do something to get out. And so he filed, he wanted to get his records so that he could look at his records and maybe file some post-conviction relief. But they responded, the DA's office responded that they had destroyed all the records of his case and that it just wasn't available, which I'm like, in my opinion, saying, what? And how is that possible? How can you destroy someone's records? Why would you do that? It just doesn't make sense, right? They didn't say it was lost in a flood. They just said that they destroyed it. So he filed and said that that's, what were the exact words, but it was maybe violating his constitutional rights, or they're not allowed to destroy them. And so it went to appeal, and they basically said that the rights of the public is that he doesn't have those rights because it passed the record in this case is void of any evidence that Mr. Pierre ever filed any application for post-conviction relief, much less identified specific constitutional errors in the proceedings leading to his conviction and sentence, including his habitual offender status. Further, the enforcement of provisions of public record laws, and they cite the laws. Since Mr. Pierre has not provided evidence that he actually is entitled to the requested documentation, we conclude that it is of no moment that the requested records no longer, that the requested records no longer exist due to the destruction of the files by the DA's office. We recognize that ordering the clerk to provide records that no longer exist would be a vain and useless act. So they're basically saying, well, because there's no proof that you have a right to the records, there's no reason for it, then we don't need to give it to you. After careful review of the record for the stated reasons, we affirm the district's court's dismissal of the mandamus action with prejudice. All costs of his appeal would be assessed to him. I wonder what the costs are. And then they list there are 7 exceptions for when they would have been responsible to provide those documents. And that goes off different violations of your First Amendment, of your rights. And then seventh one is also if they find DNA that clear convincing evidence that you're innocent. I do think it's interesting and really simply not okay to destroy evidence of a trial that is, it's where someone is still in prison. That should be illegal, in my opinion, because you just never know. And then he did something else, which, I would say is just not very smart, but because you make enemies, he sued the warden. He sued his warden, a civil lawsuit, or maybe not the warden. He sued the Department of Public Safety and Corrections. So not the warden directly, but it was on August 5th, 2019, the department accepted an administrative remedy procedure in which Pierre complained that the warden had improperly seized a $125 deposit made by his son in his JPay account. This is relatively recent to this case that was heard on 2021, just 2 years before. And basically the warden seized the money because the warden said that you can't just put money in without having the approved, where's the exact word? Seize the funds returned to his son, just requesting that. let me see okay, where it is. Shortly thereafter, in August, the department of retracted its prior acceptance of the ARP by giving him notice that the ARP was rejected. The state's basis for the rejection was that the confiscation of funds did not directly affect Pierre or his accounts and was therefore not appealable through the administrative remedy procedure. I mean, did they really just steal his money? They just took it because he wasn't on the list. It's like Pierre claims he requested a second step response to the rejection, but received no response from the department. On November 4th, Pierre filed a petition review and requesting that the 125 C's be returned to his son, which is totally reasonable. Fine. You want to take the money? You want to give me a hard time? You want to say, like, my son, we didn't follow the rules? Fine, but get the money back. I mean, come on. This is not cool. In my opinion, it's just not cool. And I think he felt so too, to the extent that he filed a lawsuit. Not that he is, but now what did they ended up saying? Failure to exhaust an issue resulting in a lack of subject matter jurisdiction. Is that bringing? Man, whenever I hear those words, I laugh. Department exception of no cause action be sustained in traversal of commissioner's recommendation. Pierre claimed he was affected by the seizure because his son sent the funds to other inmates for Pierre's benefit, and because as an inmate, Pierre also was subject to the warden's practice of seizing funds not legally classified as contraband. On February 26, 2020, the district court signed a judgment adopting the commissioner's recommendation, sustaining the department's exception of no cause of action, and dismissing Pierre's petition with prejudice for failing to exhaust administrative remedies. Pierre now appeals. I don't know, is this interesting to you guys? The Pierre argues that the district court erred in dismissing his petition on a basis of failure to exhaust administrative remedies. Okay. The Louisiana court has indicated that the primary difference between two exceptions lies in the fact that I mean, it's, I guess, they're basically, what's the conclusion? Let's jump to the conclusion. So the conclusion is, for the above reasons, on February 26, 2020, which was basically 1 year before this hearing. Oh, wait, no, this was... Yeah, 1 year before the hearing. The district court judgment dismissed the petition for judicial review filed by the appellant Derrick P is affirmed. All costs of the appeal was assessed to him. I wonder again what that cost was, because he did this all over $125, maybe also at a principal, but then he loses it and now has to pay a fine. I mean, the cost, which I wouldn't think it's cheap. It's, I don't know. I don't like it. I simply don't like the idea of a warden taking $125 from an inmate whose son gave him the money. And you might counter argue and say, look, just follow the rules, register and do what you have to do. But it just seems. I just don't like it. It just doesn't leave a good taste in my mouth. But I do think he needs to stay locked up. If this was his second time that he was caught, that makes it, there's something wrong with you. You got, how can you just, and that's caught. That's caught. You know, the idea to think that he only did it twice and both times he was caught would be silly, would be naive. And that's just scary. But I mean, he's blessed to have, it seems, intelligent, successful children. That's a blessing. With that, I'll let you go.